Good afternoon, everyone. I'm James Joshua Alvarez, your reporter for Part 7.4C, Improving Juries.
We ask juries to make important decisions that have a profound impact on people's lives. We leave these decisions in the hands of groups of lay people because we hope that the diverse range of experiences and knowledge in the group will lead to more thoughtful and informed decision making. Studies suggest that diverse groups of jurors have different perspectives on evidence, engage in more thorough debate, and more closely evaluate facts. At the same time, there are a variety of problems associated with group decision making, from the loss of individual motivation in group settings to the vulnerability of groups to various cognitive biases and errors. Moreover, jurors are often at a disadvantage because most of them have never served on a jury and many of them have never worked with a group to reach a decision about a complex problem. The judicial system is long on tradition, but in recent years, several innovations have been suggested and even implemented. Some of these reforms, such as reducing the size and the decision rules of juries, are designed to improve the general efficiency of juries and the fairness of their procedures. Others, such as note-taking, help jurors to process the evidence and testimony that they must consider when reaching their decision. So before, in the judicial system of a certain state, it is composed of a lot of jurors, so numerous jurors. So the one problem that they found kung daghan ang jurors is that the general efficiency or how they give or deliberate a verdict to a certain case or criminal case, for example. So karon they narrow it down, mas gamay ang juror tapos mas dali ang decision making. One thing that will improve the dynamics between the group of jury is the jury size. In 1970, the US Supreme Court returned a landmark ruling in the case of Williams versus Florida. Williams sought to have his conviction overturned on the grounds that the deciding jury had included only 6 persons. The Supreme Court, however, found in favor of Florida, ruling that is a 6-person jury is large enough to promote group deliberation, protect members from intimidation, fairly represent the community, and weigh the facts in the case. Jury experts, however, have suggested that the Supreme Court should have taken group dynamics research into consideration before making its decision. So modifying jury size could influence 1. Group structure, 2. Representativeness, 3. Majority influence.
Let's go to the first
4.
thing
Voting,
that might be influenced
and lastly,
when we modify
verdicts.
jury size, which is the group structure. Members of smaller juries participate at more equal rates. Smaller juries are more cohesive or mas nakaselect connection when it comes to deliberation, and members of larger juries exchange more information or mas diverse ang information na ilahang i-converse to each other and needs to be deliberated. Both of these smaller juries and larger juries have disadvantages and advantages. Ang disadvantage sa larger juries is mas diverse ang information, which means mas need siya time to deliberate to reach a certain consensus or a certain decision. Ang sa smaller juries naman is although cohesive or nakaselect connection, ang ilang information is not that so diverse. Next is representativeness. Smaller groups are not as representative of the community as larger ones. For example, if a community was 10% Latino and 90% Anglo, in all probability, about 80% of the 12-person juries selected from that community would include at least one Latino, but only 40% of the 6-person juries would contain Latinos. This is vital because in the situation in United States, juries needs to be diverse because United States is diverse in culture, so kailangan na ay someone who will represent them when it comes to groups or most importantly juries sa judicial system, because they are the ones who can understand the suspect, for example, the suspect's cultural background. Third is majority influence. The majority's influence may be greater in smaller juries because the likelihood of finding a partner for one's minority coalition becomes smaller. Best example to this is British parliamentary debate, which is the experience pod nako. As a debater,
it in British parliamentary debate, it is composed of smaller juries. So there is a big possibility na a jury will be swayed by his co-jury when it comes to giving a verdict or decision making, because mas gamay lang man ang yang composition. Fourth thing that might be influenced when we modify jury size is voting. The Supreme Court assumed that a 5-to-1 vote in a 6-person jury was the same as a 10-to-2 split in a 12-person group. But with the 10-to-2 vote, one is joined by a dissenting partner, whereas in the 5-to-1 vote, one faces the majority alone. As a result, the likelihood of a hung jury is greater in larger juries. So, ang pasabot ani is moto kung mas dako ang iyang group composition, mas lisod or mas dugay ang group deliberation. While kung gamay ang group composition, or for example 6-person jury, mas dali masway ang isa ka tao nga ni go against the unanimous decision. The last thing that might be influenced when we modify jury size is verdicts. Despite size-related changes in group dynamics, small juries and large juries do not appear to differ significantly in the types of verdicts. So dili kaayo siya layo when it comes to giving verdicts, except lang sa mga civil cases or rare cases which when smaller juries tend to return larger damages. This means that in courts, for example, kanang mga murder cases, mas gamay ang ilahang jury, mas dali ra sila maka-reach og verdict, or mas narrow ang ilahang information nga gina-deliberate because of the smaller group composition. Next to jury size is unanimity. It is defined as the state of agreeing by a group of people to an idea. In 1972, 3 men were convicted in separate trials of assault, grand larceny, and burglary by the court system of Oregon. They appealed to the U.S. Supreme Court on the grounds that their right to a fair trial had been violated because the votes of the juries had not been unanimous. Later in the ruling, the Supreme Court suggested that a 75% agreement constitutes the acceptable minimum for most juries. Relaxing the requirement for unanimity, however, changes the decision-making process in juries. Juries that do not have to reach unanimous decision render their judgment twice as quickly and are far less likely to come to a stalemate. So, meaning, kung dili kay sila maka-reach unanimous decision, they need to re-deliberate or they need to reassess the information in order for them to reach that certain level of agreement. Next to unanimity is procedural innovations. Whereas jurors were for once forbidden from taking notes or discussing the case prior to deliberations, in a series of modifications, courts have experimented with various types of procedural changes to determine if notes help jurors to remember and process the volumes of information they receive during the trial. For example, the courts have worked to try to clarify information about the legal terms used in the case under consideration. The revised wording for such concepts as reasonable doubt and preponderance of evidence, for example, has triggered changes in how long juries deliberate in their eventual verdicts. This means to say na through time, taking note is really vital, especially when jurors needs to listen to every information that they need in order for them to reach a certain verdict. It is also the same to us debaters when we adjudicate a certain debate. So in adjudication, there really is a need for you to take note in order for you to remember those important informations during the discussion. Last thing that is needed for the group dynamics amongst juries is voir dire. It is defined as the oral or written questioning of prospective jurors by counsel or the judge. It is an alteration of French word vrai dire, which means to speak truly. Until the 1970s, voir dire was left primarily to the judge's discretion. Defense lawyers could submit questions, but judges were free to disregard them if they desired to. However, When convictions were overturned on appeal because trial judges had disallowed defense participation in voir dire, trial courts began opening up the jury selection procedure to attorneys. Systematic jury selection, when lawyers carefully study the prospective jurors in the pool and use voir dire to identify sympathetic and antagonistic jurors, is now common practice in major trials. In debate, it is called as interpellation, or kung murag maghatag ka og question, important question to 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 solidify your stance, or to clarify some certain information to a certain case. Social psychologist Lawrence Reitzman, an expert on psychology and the law, has argued that judges should limit the number of jurors that lawyers can challenge during voir dire. He also recommended stricter guidelines for lawyers who sometimes use the voir dire process to influence the jurors in their favor. Reitzman suggested that voir dire questioning be carried out carefully so that jurors will respond honestly and that judges supervise the process more closely. Voir dire is a useful way of identifying highly biased individuals, but it should not be a means of manipulating the composition of the jury. This simply means that smaller group of juries is much more efficient when it comes to giving verdicts or decision making to a certain case. That would be all. Thank you.